At the beginning of the hearing, the judge explains that the case was filed because of unpaid rent and invites the landlord's representatives to prove why the tenant should be evicted. They state that the tenant owes a total of $2,824 in past due rent going back to December 2025. The monthly rent under the lease agreement is $1,225. They confirm that the tenant's last zero balance was in November. The property management company took over the property in December and says the tenant already had a past due balance at that time. The property address is confirmed as 3512 South 4th Street. The judge asks who the actual property owner is. The managers confirm they have a property management agreement with the owner. The discussion establishes the basic facts of the unpaid rent and management transition.
You all filed this case against him with the complaint of non-payment of rent. And so without further ado, I'm going to give you the opportunity to prove to me why he should be evicted. Go ahead.
Hi, Judge. So he has a total amount of $2,824 that's due, past due in rents, going all the way back to December 2025.
Hmm.
So December, January, and February.
Monthly rent, according to the lease, how much did he agree to pay on a monthly basis?
$1,250.
So the last time he had a zero balance was in November?
As far as we know, yes, sir. We took over this property from a different management company in December, and when we took over the property, he came with a already past due balance.
This is the address in question is 3512 South 4th Street, right?
Yes, sir, that is true.
Who's the actual owner of the property?
Let's see.
Owner. I can get it.
Yeah, she's going to get that for you, Judge.
And so you all have a property management agreement with the owner, is that correct?
That is
Yes.
correct.
Okay. So, I see here you filed with the court the military affidavit. You stating that you're not able to determine if this person is actually enlisted in the military.
The judge reviews the military affidavit filed with the court and notes that the managers could not confirm whether the tenant is actively enlisted in the military. They admit they do not have the tenant's date of birth, driver's license, or application records. The judge asks whether they have had any contact with the tenant, identified as Sean Tompkins. The managers explain they tried reaching him through text and email but received no response. They believe he is still living at the property and recently visited to post a notice on the door. However, the property was deadbolted, preventing entry. They confirm they also mailed the notice by first-class mail. This section focuses on contact attempts and service of notice.
Is
That's
that right?
correct. Yeah, that's correct.
So you all took this over. You don't have any information on him, such as a date of birth or driver license, anything like that. Is that right?
No, we don't have the application of the person.
Have you all had any contact with this man, with the Sean Tompkins?
I've reached out several times via text and email. No response whatsoever.
To your knowledge, is he still staying there?
As
Yes.
far as we know, yes.
When was the last time y'all been by the property?
Yes, sir. We were just there the other day when we posted the notice.
Okay. So you posted the notice to the front door? Like, did the
Correct.
app-
It was
the app-
deadbolted. We couldn't get in. It was deadbolted, sir.
you also mailed it, all right?
Yes, sir. Mhm.
You all aware that these laws have changed?
Would I have not been, I'm not aware of any changes, no, sir.
So y'all members of TREC?
I'm
Yeah.
sorry, what?
Are you all members of TREC? Are you licensed real estate agent?
The judge informs them that eviction laws changed effective January 1, 2026. The managers say they were unaware of any updates. The judge asks if they are licensed real estate agents or members of professional organizations, and they clarify that their broker is licensed, but they personally are not. The judge decides to share the updated property code, specifically section 24.005, to explain the changes. He emphasizes that although the section number remains the same, certain methods of delivering eviction notices have been amended. Posting a notice on the outside of the door has been removed as a valid method. The judge advises them to consult their broker to ensure compliance with the new legal requirements moving forward.
No.
No,
Oh,
we have a licensed real estate agent
Yeah.
in our office, and also our bosses. The president is a broker.
okay.
So we have it here in the office, but Sarah and I are not one of those. No.
So you all, according to your petition, you mailed it as well, right?
Yes.
How did you, and you mailed it via first class mail?
Just regular with the postage stamp.
First class mail, okay. What I'm gonna do, and this is something that you want to get with your broker on and a real estate agent. Effective January 1st, the legislature's made some changes to the laws as it pertains to evictions. And so what I'm gonna do is I'm just gonna share my screen with you, the actual property code that's in question right now. And then you all can just take note of the code and get with your broker to make sure that you are in compliance of the new updated laws. All right.
Okay. Yes, sir. Thank you.
So I'm going to share my screen. That way you all will see exactly what I'm referencing. All right. Can you see my screen?
Yes.
Okay. So
The judge carefully explains Property Code Section 24.005 and focuses on subsection F, which covers notices to vacate. He clarifies that while some delivery methods remain unchanged, others have been updated to remove confusion. The law now requires that notice be delivered using at least one approved method. Mailing by first class, certified, or registered mail is still acceptable. However, simply posting a notice on the outside of the door is no longer recognized as valid. The judge highlights that the managers must fully understand the updated code. He stresses that professional guidance from their broker is necessary to avoid filing improper eviction cases in the future.
on February 5th. Let's see here. So 29th, using the post office box rule. I don't count the 29th. 1, 2, 3. Postmaster had 3 days to deliver the notice. 1, 2, 3. Tenant had up until the 4th to comply with said notice. Case was filed on the 5th. All right. You stated under oath that the defendant had a record of not paying rent. And you provided me with a tenant ledger. And this goes from January to February. And then you have here some transactions from the does this come from the previous
Yeah. Yes.
Okay. Okay. So tell me what's going on with these transactions going from December 9th moving forward.
From the previous management.
Mhm.
All I know is he came over with $324.15 still due for December, and he had a late fee of $125 for November and another late fee of $125 for December.
So as far as these refunds and stuff like that, that's y'all don't know anything about that. As far as $1,000
That
refund.
was, yeah, that was from the other management company. They said that I guess he had tried to make a payment and they refunded that money back to him
Because they were no longer managing the
because they were
property.
no longer managing.
So how did you all notify him that you're the new manager or that way, you know, how would he know to pay you all instead of the old management company?
We send it out via email and through text message.
Okay. Did you get any type of confirmation from him?
We can see when the tenant.
The judge introduces the post office box rule when notice is mailed. He explains that the day the notice is mailed does not count toward the timeline. The post office must be given 3 days to deliver the notice. After delivery, the tenant has 3 days to comply with the notice to vacate. Weekends are included when counting these compliance days. If the final day falls on a holiday, filing can begin on the next business day. The judge carefully walks through an example using specific weekdays to clarify the timeline. He emphasizes that eviction is a civil suit and proper date calculation is critical. This section provides detailed procedural instruction rather than legal advice.
Opens the email. We can see when it delivers. We can see when they open it.
Okay.
And the only response I ever got back from him was he hadn't received the refund back yet from the other management.
Okay. So he did acknowledge that you all are the new property managers.
Yeah.
And he said that I'm waiting on my refund from the other property management company before I pay you all. Pretty much.
Yeah, he just said he hadn't received a refund back yet.
Yeah. Okay. So this is what I'm going to need. And was that was text message, right? That he sent you that message or email?
Yeah, text message.
All right. So this is what I'm going to need. All right. I'm tell you what I'm gonna need, and I'm gonna tell you why I need it. All right. So that last text message that you told me that he communicated with you, this is your verbal testimony. I need you to send me a copy of that, and that is going to accompany your affidavit of military status, because you really don't know if he's in the military or not. But if you can prove to me that you had some type of communication with him, from the time, from that date forward, then I can use that to accompany your military status. Okay. All right.
Okay.
Now, the next document that I'm going to need is the property management agreement between you and the owner. And I'm also going to need an amended petition, which would include the owner's name / campus realtor. And the reason why I am requiring that is in the event that the owner decides to fire you, just like he fired the other owner, and if the judgment debtor, Mr. Thompson, wants to pay, that money shouldn't go to you. It should be payable to the owner. And our records need to reflect owner's name / campus realtors in the event that the defendant decides to pay the amount that is due on the judgment. It should be payable to the owner, not campus realtors. Once I receive those, I will grant judgment in the owner's favor and have copies sent to both parties at the addresses of record. Any questions, ladies?
So do we just make that amendment ourselves, type that up?
Well, you would just, do you have a copy of the petition?
Yeah, you just have to,
Yeah.
I know what he's talking about.
Okay.
If you have a copy of the petition, just, you can just put right at the top of it, owner's name, and just initial it, and then just send that to me. Yeah. In other courts, you don't do it, I know, but it's just a process that I do because, again, if one gets fired, I've had issues with owners saying, hey, where's my money? And we had to explain to them when the case was filed, management company didn't list you as the owner, so they're going to pay that management company, not you.
Okay.
So And we just try to eliminate that. All right. Any other questions?
The judge explains the updated acceptable delivery methods. Notice can be delivered inside the premises in a conspicuous place, rather than specifically taped to the inside of the door as required under the old law. It can also be hand-delivered to a tenant over age 16. Electronic delivery, such as email, is allowed only if both parties previously agreed in writing to communicate electronically. The judge warns that if notice is placed outside the door, proof of actual receipt must be shown. He stresses again that the managers should consult their broker before filing future cases. However, since they testified under oath that they mailed the notice, the judge proceeds with the case.
Questions, ladies?
So do we just email all this stuff over to you, or do we need to bring it up there?
You can email that. Don't worry about bringing that up here. Email that. And email it. Email it to the JP2. Do you have that email, the JP2 at mclennan.gov?
What is it?
JP2 at mclennan.gov.
Got it. And again, check with your broker and the realtor in the office just to make sure that y'all are in compliance with the new laws moving forward. All right.
Okay, thank you.
Right. The purpose of today's hearing is in regards to your statement of inability that you filed pertaining to an appeal that you'd like to have forwarded to the McLennan County Court of Law. You were the defendant in a civil case. You filed this statement of inability, and you are the Joe Ted Oliveira, owner of America Roofing, correct?
Yes, sir.
In your application, you indicated that you could not afford the appeal bond.
That's true.
All right. I'm going to give you the opportunity to provide testimony as to why I should grant your request to have your case appealed in lieu of paying the bond. Go ahead, Mr. O'Hara.
The reason I'm low on funds is because for us the roofers, December, January, and this month are the hottest month to make profit. We don't have much going on, and I feel sorry that I was not able to come up with that money. But if you give me an opportunity to do so, I will take care in the future.
Okay. In your statement of inability, you swore on a penalty of perjury that everything was true in this application, right?
Right.
However, you did not include any documentation or any indication of the roofing business that you own.
America Roofing I'm the owner.
Yes, you in your application, you did not list any thing regarding the company that you own. The purpose of the statement of inability is for those who have no financial means to either pay the bond or get a surety. Do you understand? Do you know what a surety is?
I never been in this situation. I'm so sorry, but what's that mean? That means
So a surety is they would act as a bond. It's a bondsman. So what they would do is they would take they would work with you in making payments or whatever to them on a monthly basis, and they may want to secure certain assets from you. you know, because you're asking them for help, and they could possibly provide a surety, which is a document that would take the place of you paying the bond.
Ah, see, I understand now.
Yeah.
Yeah.
Uh,
If you,
unfortunately, I cannot honor your statement of inability because you did not include all of your income as well as debts that pertain to your company. The only thing that you listed was personal income that you received, but nothing that indicated or nothing that contained the uh, financials of your business.
I see.
And
Well,
so,
if
go
you
ahead.
if you give me the opportunity to work it out on those papers, I will do. I will do whatever you require me to.
Okay, I tell you what I'm going to do. I'm gonna put you back in the waiting room, and then I'm going to make sure I give you the correct timeline on providing me with an alternative to this statement of inability to have your case appealed to the higher court. Okay, so I'm going to put you back in a waiting room, and then I'll be back with a timeline or a date for you to have the surety.
Thank you, my honor.
All right. Okay. And also, I'll ask you this: are you working with an attorney?
And no, not yet, not yet. I don't have the money to do that. But if that's the case, if I need it, well, I guess I let know.
And the reason why, because most attorneys, they some act as sureties uh, to have your case appealed to the higher court as well.
I will find out. And
Okay.
I'm so sorry. This month is hard and
Yes, sir. Yes, sir.
it's
All right. I'm gonna put you back in the waiting room, and then I'll give you a timeline as to when you would have to supply the court.
thank you, my honor.
Okay.
Thank you so much.
All right. And so, according to the rules that we have in place, I have to give you at least 7 days to correct the irregularities in regards to your statement or your appeal. Okay. In this case, it'll be your appeal. So you have 7 days from today's date to provide the court with a surety or sureties or the actual bond. All right. So you have 7 days from today's date. So that date is going to be the 25th. Okay. So the seventh day actually falls on the 24th, but since my court closes early, I have to give you up until the 25th. Okay.
Yes, sir.
In the event that I do not receive the surety or sureties or the cash bond, then your case would not be considered perfected, or your appeal would not be considered perfected. Okay, go ahead.
My honor, is there some way you can give me a little bit extra time, like let's say 14 days?
No, sir. These are the rules that the legislature's put in place, and the maximum I can give you is 7 days. So you have 7 days to either retain an attorney, your attorney can handle this for you, or you have 7 days to handle this on your own. Okay?
Thank you, my honor.
Okay. All right. Good luck to you, Mr. O'Vera.
Thank you so much. Have a blessed day.
Yes, sir. What's your journey? So the reason why we are here today was because of the service on the defendant. It was placed on the dismissal docket because the private process server apparently had the incorrect address for the defendant. Whenever I placed it on the dismissal docket, I sent notices to both parties at the addresses of record. So the postmaster delivered the notice to you, Mr. Jones. Is that correct?
I think so, Your Honor.
Okay. I'm just gonna say this.
The judge reviews the timeline of this specific eviction. The notice was mailed on January 29. Using the post office rule, he counts 3 days for delivery and 3 days for compliance. He determines the tenant had until February 4 to comply, and the case was filed on February 5, making the timeline valid. The judge then examines the tenant ledger, including transactions from the previous management company. There were late fees and a $1,000 refund processed by the prior company. The managers explained that the tenant claimed he was waiting for a refund before paying them. The judge requests proof of the last text message communication to support the military affidavit. He also requires the property management agreement and an amended petition listing the owner's name to ensure payments are properly directed.
Miss Williams, there was a previous case filed by another plaintiff against this defendant, Mr. Jones.
Okay.
In that hearing, Mr. Jones informed me that there were some issues with a caretaker who was his power of attorney that was handling affairs. However, that power of attorney no longer has been, pretty much released or pretty much quit.
Okay.
And
Another case concerns improper service of a defendant named Mr. Jones. The private process server used an incorrect address listing an apartment number at a single-family home on Carver Street. The judge explains that he knows the area well and confirms there are no apartments at that address. He also mentions prior information that Mr. Jones is a war veteran who cannot manage his financial affairs and previously had a caretaker acting under power of attorney. That caretaker allegedly mishandled matters and may have caused the debt. The judge encourages both parties to speak privately in a breakout room to discuss the situation. He allows time for possible hardship review or fraud investigation.
to another city, and he now has someone else assisting him with his financial matters. He's a war veteran who is not able to make decisions on his own, and the debt he had was initiated by that caretaker.
The previous caretaker. Okay.
So with that being said, I'm going to ask if you and Mr. Jones would like to speak privately regarding this particular case.
Okay.
See how, what we need to do to move forward. Again, the
Okay.
issue was initially in regards to service, but apparently the postmaster did deliver my notice to the defendant. However, the defendant was never served, to my knowledge, with the correct citation and petition.
Okay. Understood. And I'm showing in my record, I didn't have the information that you just provided, so I do appreciate that. I had shown that we had requested alternate service. I don't know if that was okay. And it still went to the wrong address?
Yes. So the address. So here's the problem that I had with the. I know every street in my precinct.
Yeah.
With that being said, the address on the petition was 508 Carver Street, apartment 7704.
Okay.
508 Carver is a single dwelling unit.
Okay.
No apartments associated.
No apartments. Okay.
No. Back in the 80s and 90s, there were apartments at 200 Carver, but at 508 Carver, it's a single family dwelling.
Single home dwelling. Okay.
And that's whenever the last representative that came, I informed them of that, and that's when they requested additional time to have the defendant properly served at the correct address.
Okay.
Again, from what I learned in a previous case, someone else had been handling his financial matters, and that's may have been where the mix-up in the address on his original, um, I guess, application for credit.
Okay, understood.
I don't know.
Yeah.
All I know is that he can't handle any financial matters.
I Your Honor, would like to have this reviewed as a possible fraud case. I would definitely like to have them review it as a hardship, considering
The hearing shifts to a new case involving Joe Ted Oliveira, owner of America Roofing, who filed a statement of inability to afford an appeal bond. The judge allows him to explain why he cannot pay. Oliveira states that winter months are slow for roofing business and he is low on funds. The judge notes that Oliveira did not include business financial information in his sworn statement. The purpose of such a filing is for individuals with no financial means, and business assets must also be disclosed. The judge explains what a surety is and how it can replace a bond. Because of missing financial details, the judge denies the statement of inability but grants 7 days to provide a bond or surety. He refuses to extend the deadline beyond what the law.
Defendant,
okay,
okay?
with the defendant. Okay,
So, Mr. Jones, I'm going to put you and Miss Williams in a breakout room. It's going to be a private room where you and her will be able to talk about your situation, how this account got to this point. Okay?
Yes, sir, Your Honor.
All right. So just accept the invitation, and whenever you're through, just come back in, and then I'll give both of you another date and time to come back. Okay?
okay. Thank you, Your Honor.
All right. So this is what we're going to do, Ms. Williams. I know you had the opportunity to speak to him. So seeing that he's never been served with citation in the petition and so forth, what I'm going to ask you to do first, if you want to continue on with it, which, we still got to go through the process, make sure your private process server redacts that apartment.
Yes, definitely.
Have them resubmit at that time, or they can, resubmit if they want to use alternative service. I'll grant it right address. Once he's sued, then we could put it on the docket, and then we could entertain any motions and so forth in regards to this.
Very good. Okay, sounds good. Thank you so much, Your Honor.
Okay, so at this time, this case is pending, waiting for the confirmation of service on the defendant. Okay.
Wonderful. Thank you so much.
Okay.
You have a great one. All right.
To the private discussion, the judge instructs the plaintiff to correct the address and properly serve the defendant. The incorrect apartment number must be removed before re-attempting service. Once proper service is confirmed, the case can be placed back on the docket for further motions. Until then, the matter remains pending. The judge closes by thanking the parties and reminding them that proper procedure must be followed. The hearing highlights the importance of updated legal knowledge, accurate service, complete financial disclosure, and fairness in civil court proceedings.